I hope you're able to see me, you're able to hear me. Okay, great. Yes, thank you. So today we are going to further discuss about thoughts. So this would be a second last session. So like I told you, if you have any doubts with reference to what we have studied so far. Okay. So I hope I'm audible because some of a couple of you are saying I'm not audible. Okay, great. I guess there was some network issue, so I got lost for a. So I hope I'm audible. Great. Okay. Yes, I'm good. Thank you. Yes, so we discussed about damnums and injuria. We discussed about what are exceptions to the strict liability as well. Now we are going to, we also discussed about vicarious liability. Now we are going to go ahead on torts or wrongs to personal safety and freedom. Yes. So basically, an action for damages lies in the following kinds of wrongs, which are styled as injuries to the person of an individual. Now, what is this? Injuries to the person. Okay. Now, just concentrate over here. What is injuries to the person? So now we are going to study in detail about battery. What is assault? Okay. So what is battery? Now, battery, any direct application of force to the person or another individual without his consent or lawful justification is a wrong of battery. Okay, so what is battery? Again, please concentrate over here to understand what is battery. So basically, in order that you can call this as a battery, what is important is two things. First, there is a force, use of force, however trivial in the sense, even if it is a, you say, oh, I didn't do that much. It's not like it's a great force which I have used and I've pushed the person. No, I've just done a small usage of force. So here, usage of force, however trivial, it may be without the plaintiff's consent and without any lawful justification. So here, it is important that it is without the, it may be, now the words used are may be, without the plaintiff's consent and without any lawful justification. So even though the force used is very trivial and does not cause any harm, the wrong is committed. Thus, even to touch a person in anger or without any lawful justification is battery. Now you have to understand what are the ingredients of battery and when you can say that, okay, this is a battery. So here, battery can be, it need not be that a physical harm has been made to the person. So if you push somebody from the staircases, now maybe the person did not get hurt and did not have any kind of it was not obviously with his consent, but here you push that person. So whether can be called as battery, whether it is an assault is what we are going to see, assault as well, and then you're going to give the answer to this question, that whether it is a battery if somebody is pushed from the place where he is standing. Now whether this is, now it can be a small force or it can be a huge force which is being applied and the person is pushed. So whether it can be termed as battery or it can be an assault. So we'll also see assault, and then you'll get a further differentiation between what is a battery and what is assault. Okay. Now assault is an act of the defendant which directly causes the plaintiff immediately to apprehend a contact with his person. Thus, when the defendant by his act creates an apprehension in the mind of the plaintiff that he is going to commit battery against him, the tort of assault is committed. Now, for example, I just did this action to somebody in front of. So, I intended to slap a person, for example. Whether it is an assault or whether it is an battery, what do you think? Yes? Did you get the question? So I did not slap the person, but I just took my arm, up in the air, and I'm just going to do this action. So whether it is an assault or it is a battery. Now try to correlate with the words which are being used over here. Assault is any act of the defendant which directly causes the plaintiff immediately to apprehend a contact with this person. So, did you feel that, oh, she's going to beat now, right? So there is an apprehension. I may or may not do it. It's a different story. But there is an apprehension that this person is going to slap the person, right? So there is an apprehension. So this is what we call as apprehension. I did not actually beat somebody, but it is an apprehension that this person is going to contact and beat. Okay. So thus, when the defendant by his act creates an apprehension means the fear that this person is going to beat me, in the mind of the plaintiff that he is going to commit battery against him, the tort of assault is committed. So you get this. The law of assault is substantially the same as that of battery, except that apprehension of contact, not the contact itself, has to be established. So even if there is an apprehension, there can be an assault. The law of assault is substantially same, means battery and assault are more or less similar. But what is the difference? The tort of assault, uh, except that the apprehension of contact. So apprehension, even if there is a fear that this person is going to beat, it is assault, not the contact. So it is not necessary that I should actually, there should be a physical contact by slapping the person. Okay, it is not necessary, but not a contact itself has to be established. So even if it is shown, no, that she did this action by which the other person intended that this person is going to beat or slap the other person. So usually when there is a battery, there will also be an assault. So like we see, now if you see battery, what is their use of force? So there is a physical contact. There is a physical contact which is happening. There is a use of force, and it may or may be without plaintiff's consent, and of course without any lawful justification. Now for example, police kind of detaining a person, or an arrest warrant which is being arrest warrant is there on a person, and the police is taking that person to jail now, or police station for that matter. So here, can you say, oh, this police person kind of touched me and now they're dragging the person to the police station? It won't be said, because it is with a lawful justification. They have got an arrest warrant and stuff like that. So here, it is not that there is no lawful justification. There is a lawful justification, and that's why it is being done. So here, can it be said that the police is committing battery, or they are or there is an assault? No, because there is a lawful justification to it. But So that's why if you see battery, what important factor is there is a physical, there is a force involved, and the second important ingredient is there is a no without any lawful justification. Whereas assault, if you see, even if there is an apprehension, there is a fear. It is not an actually somebody has beaten somebody, thrashed somebody, but even if, for example, there is a stick which is being shown and just being thrown in a manner that the other person is fearing that okay, this person is going to beat me or likewise. So here there is an apprehension. It is not necessary that the other person may or may not. Of course, if somebody slaps, it is naturally a battery and assault, because what is here, defendant by his act creates an apprehension that he is committing battery against him. The tort of assault is committed. Okay, the law of assault is substantially the same as that of battery, except that apprehension of contact, not the contact itself, has to be established. Usually, when there is a battery, there will also be assault, but not, for instance, when a person is hit from behind. Now, when somebody is hitting from behind, obviously you don't have that apprehension that okay, somebody is beating, because A, you don't know that somebody might beat you from behind. So, to point a loaded gun at the plaintiff, or shake first under his nose, or to curse him in a threatening manner, or to aim a blow at him which is intercepted, or to surround him with a display of force is to assault him clearly if the defendant by his act intends to commit a battery and the plaintiff apprehends it is an assault. So now you get the difference. So here, now for example, a person is surrounded by 10 persons, like you see typically in the Hindi movie, right? The hero is being surrounded by 10 different people. Now they have not caused the harm, so the battery is not yet committed, that there is no physical force. But there is, you say it as an assault? Yes, because there is an apprehension that all these 10 persons are going to beat a single person. So here, what is important is there is a fear which is being created that the other person is going to harm. And when the person actually harms, it is also a battery. So assault, if just a gun is loaded and put, so it is an assault because there is an apprehension or fear that this person might act. Now you don't have to wait till that afterwards. So afterwards the person goes. You don't have to wait till the person shoots that person. No, you can go and say, oh, this was an assault. So basically, this assault can be in terms of various ways by which there is an apprehension in the mind that the other person is going to commit a battery against him. So I hope you now understand battery and assault. Okay. Now we'll go to bodily harm. So a willful act or statement of defendant calculated to cause physical harm to the plaintiff and in fact causing physical harm to him is a tort. So a willful act. Now here if you see, a willful means it is not that unintentionally you say something. It is with full intention, with full knowledge, with full understanding of the consequences of what is going to happen. A person does this, that it causes, he or she causes a calculated to cause a harm. So basically it is done to harm the physical harm the person, then of course it is in fact causing physical harm. So it is not just an apprehension now, and in fact causing bodily harm to him is a tort. Now I guess this is very easy that you understand that when a bodily harm is being present, ingredients. Now we'll go to false imprisonment. Now what is false imprisonment? False imprisonment consists in the imposition of total restraint for some period, however short, upon the liberty of another without sufficient lawful justification. Now here the important words which are being used are imposition of total restraint for some period. It can be for a short duration. So if it can be for a few minutes, the answer is yes. Can it be false imprisonment? Yes. So the period here is not important. But what is important, it is an imposition of total restraint upon the liberty of another without sufficient lawful justification. So what here important is, without, again, there is no lawful justification for it. It means unauthorized restraint on a person's body. So we can understand there is a lawful justification when a person is being detained, he's put under inquiry, he's put under arrest, or likewise, whether it's a lawful justification or a person's passport has been impounded, and likewise. But again, if the person is restrained for some period, upon, and there is a liberty, now we, why, if you refer to that, we have a right that we can go, we can practice profession, we can travel, of course, but that comes with the conditions attached to it. So here, if without any lawful justification and there is a restraint means temporary stoppage or a stoppage, it can be a total restraint. So here what is important is a total restraint for some period, however short, upon the liberty of another, then it becomes a false imprisonment. What happens in false imprisonment is that a person is confined with certain limits so that he cannot move about, and so his personal liberty is infringed. It is a serious violation of a person's right and liberty, whether being confined within the four walls or being prevented from leaving place where he is. If a man is restrained by a threat of force from leaving his house or an open field, there is false imprisonment. So basically, when, if you say that somebody is being house arrested, now, of course, it is, if there is no lawful justification to it, then of course you can say it is false imprisonment. So if somebody is being locked in a house and he is not able to move out of that house because he is locked, and you say it is a false imprisonment? Yes, what do you think? Did you get the question? So if somebody is being locked in the house, okay, so here what you have to apply is whether the ingredients of false imprisonment are present. Now, what are those? Imposition of total restraint for some period. So you have been, if somebody has been, A is been locked in a flat, for example, and there is a lock and key attached to it, and the person who is kind of locked him in that flat is only the person who has the key, and he, upon his understanding, he will open the key, otherwise open the lock, or else the person will be always in the flat. So whether this is a false imprisonment, you will have to apply imposition of total restraint for some period, however short, upon the liberty of another. Now, can that A get out of the flat if he want to roam around, if he wants to go to office, or if he wants to buy groceries? Can he do that on his? No, he cannot do that. And whether it is a lawful justification that why Mr. A is been put under lock and key? No. So can you term it as false imprisonment? Yes. See, imprisonment, what we understand is putting behind the bars, is what we understand. But here it is not about the police, or as per the court order that a person is imprisonment or like imprisoned or likewise. Here it is that's why it is called as a false imprisonment, because it is created as if there is a bar on the restriction of movement of a person. So by which, now even if, for example, a person is put in a meeting room or a person is put in a kind of a garage, all this can be a false imprisonment, because a imposition, conditions have been created likewise that the person is not able to move as per his convenience. Okay, so I hope you get it now. False imprisonment. Now we are going to see about malicious prosecution. Malicious prosecution consists in instigating, now this word is very important, instigating judicial proceedings, usually criminal, against another, and maliciously and without reasonable and probable cause, which terminate in favor of that other and which results in damage to his reputation, personal freedom, or property. Now, this is again very important. Now, please concentrate because the essential elements of this dot are given below. So, first, what there must be? There must have been a prosecution of the plaintiff by the defendant. So, this is very important. Then, what is there? There must have been a want of reasonable and probable cause for that prosecution. So, A, there must have been a prosecution, then there must be want of that reasonable and probable cause for that prosecution. The defendant must have acted maliciously, uh, that is without with a proper with an improper motive and not to further the end of justice, and the plaintiff must have suffered damages, so there must be some damages as a result of that prosecution, and the prosecution must have terminated in favor of the plaintiff. So here, if all these ingredients are present, then what we can say, yes, there is a malicious prosecution is what we understand. So here, if you see, these are all the ingredients of malicious prosecution. Now, to be actionable, the proceedings must have been instigated actually by the defendant. So, if he merely states the fact as he believes them to a policeman or a magistrate, he is not responsible for any proceedings which might ensue as a result of action by such policeman or magistrate on his own initiative. Now, sometimes what happens is that if there is a person can be a witness to a particular incident. Now, he may not know the full story, or he must have seen only half portion of the story, or he must have been only knowing what he is saying. He may not see the full picture behind it. So here what happens is, if you apply here, if he merely states the fact, now he must have seen a person beating somebody. Now he might not know whether what happened previously, that the person first was instigated and then this person started beating the other person, or likewise. So he just saw the partial facts. He did not see the whole picture. But what he saw was right, that the other person was beating. So, for example, A was beating B, is what he saw. But he did not know that before that fight started, it was B who instigated A, and B who was first beating A, and then when he came, A started beating B. So here, if he says that to the policeman that yes, I saw A was beating B, then what if you correlate here? If he merely states the fact as he believes them to the policeman or a magistrate, he is not responsible for any proceedings which might ensue as a result of action by such policeman or magistrate on his own initiative. So here it becomes important that if he is, so it is not, if you see the ingredients are what? Malicious prosecution consists in instigating judicial proceedings against another malicious. So this word malice is very important. It, and if you see the example which I quoted, there is no malice involved. Okay, there's no malice involved in this particular kind of example which I gave. So that's why whether can this be treated as malicious prosecution? The answer might be no, because if he merely states the fact, because he just mentioned the fact, and that's why it cannot be a malicious prosecution. Okay, so we now go to the next, that is nervous shock. Now, this nervous shock is comparatively of recent origin. It provides relief when a person may get physical injury not by an impact example by stick, bullet, or sword, but merely by the nervous shock through what he has seen or heard. So, causing of nervous shock itself is not enough to make an actionable tort. Some injury or illness must take place as a result of emotional disturbance, fear, or sorrow. So, sometimes what happens, we typically see that the person is not kind of being physically injured. It is a shock which through which the person goes, and it is not just by so when a person may get physical injury not by an impact. Okay, because if you see the person did not get any physical injury, in the sense, can you say it was a battery? Then of course you have got battery, you have got assault for the other person's oh, this was a battery, or this was an assault, or this is a bodily injury. But here there is no physical harm. If you see, physical injury is absent, but what is there? It is an impact or a mental state of mind. So basically, if you see, if it is a mental state of mind, because it provides relief when a person may get physical injury not by an impact, example by stick, bullet, or sword, but merely by the nervous shock through what he has seen or heard. So physical injury is there, that the person has been injured, but it is not by some force, or like we see that by a stick or a bullet, or like it is a shock. If you say, why we say, oh, there is a nervous shock, which what we typically understand, because causing of nervous shock itself is not enough. Now here what is important is, only nervous shock is not enough to make it an actionable tort. Some injury or illness must take place as a result of emotional disturbance, fear, or sorrow. So here what is important is just because see, unfortunately, when people see something bad or there is something, then they go into some of shock for some seconds, so that how this happened, or what is the instance and by which this happened, and like, they go into a shock for a temporary state of mind. But whether this is enough to show that there was a nervous shock, the answer may be no, because there must be some injury or illness. So if there is a proof that because of this particular incident, this illness has been caused to the person, then of course you can say that this is a nervous shock. Like is being said here, this branch is comparatively of recent origin, because we understand that not every time uh, the impact has to be in terms of injury, like an assault or a battery, right? There can be a example of nervous shock by which an illness has been created. This is very important. There has to be some injury or illness. So okay, so that makes a person emotionally disturbance is there, and fear and sorrow is there. So that is important. Okay, there is one question, is nervous shock and assault the same? So if you see, nervous shock is what? It is a shock itself is not important. Illness or injury is important. Whereas if you see assault, there is only an apprehension that, okay, if this is the case, there's just an apprehension. Now, I'm not getting into a nervous shock or likewise. I may not go instantly into depression if somebody just kind of is going to slap, right? So there is a difference. So assault can be where there is a temporary apprehension that the person might beat. So whether there is a, so it doesn't lead instant to a depression or if in illness of some kind or an injury of some kind. It doesn't lead to always that. So whether if there is an illness which is created, then it is nervous shock. Okay, so nervous shock, what is important is there must be an illness or injury as a result of the emotional disturbance, fear, or sorrow. So that is very important. Now we are going to see defamation. uh, Defamation is an attack on the reputation of a person. It means that something is said or done by a person which affects the reputation of another. Now, I hope you must have heard about this. I'll file, even in jokes, we say, I'll file a defamation case against you. You're defaming me, right? So, this word defamation is not very new to you. And even in the given situations around, these words have always been used that, okay, I'll file a suit of defamation against you, and likewise. So, what is defamation? Defamation is the publication of a statement which tends to lower a person in the estimation of right thinking members of society generally, or which tends to make them shun or avoid that person. So there have been famous cases of defamation. There have been famous cases around defamation where a person's reputation is being. So if you heard something about your favorite personality, be it a political personality, or be it any other personality which you really feel that this person is an idol of yours, and it's such a great person, and likewise. So whenever you hear a statement being made of that person, you may feel that, oh, really, that, oh, bad, and then suddenly you find that person really bad, and then you feel that, oh, whatever I thought about this person is not right, right? Yes, so there are many examples of defamations which are there. So recently there were also few cases where people, if you must have heard about hashtag Me Too movement. So there was a lot of debate on this hashtag Me Too movement where some personalities, film personalities, journalists were accused of sexual harassment, and then they also filed a defamation case against these people involved that, oh, you're lowering. Now if you see, this is what happens: lowering a person in the estimation of right thinking members of society generally, and or which tends to make them shun or avoid that person. So when you see that this person, oh, is this person is a, for example, if somebody tells that, oh, this person was a sexual harasser, so then obviously you would say, oh, really, this person is a sexual harasser, oh, this is bad. Then you will suddenly want to shun. Then for example, if it is social media, then you unfollow that personality, you don't like that personality anymore, and you want to avoid that. And if this person was high in your mind, because of, if you understand that this person has been a sexual harasser, suddenly the image will be down, and you will feel, oh, this person is bad because this is a sexual harasser as per what this girl or woman is saying. So what happens is, defamation is a publication of a statement. So here there is a publication of a statement made by an individual which tends to lower a person in the estimation of right thinking members of society generally. Okay, there are questions that Sushant Singh is the kind of case. I don't think, because a Sushant Singh, unfortunately, now we don't know the reasons, or whether we don't know whatever is still the uh, still has been proved. But what we understand is he hanged himself, and what is coming in the media or as per the reports is it was depression. Now the question is, there have been lot of being talked about nepotism, and there is also an FIR against some famous film industrial persons. Yes. So now whether those persons can file against defamation can be the question here. That, oh, you are because of your linking us, for example, to this particular case of suicide. Now whether because of which your statements you're making a lower you're making our people think that we are bad persons. Now whether they can file a defamation is the question. So that is a question, whether they can file a counter suit for defamation, that you are intending to by your statements and linking to us to this particular suicide which has happened, you are lowering our estimation of right. So if you see, for example, there was a news that there were a lot of changes in the followers of these persons on social media. So that can be treated that yes, because of this linkage of this famous personalities with the suicide case, it tends to lower a person's estimation. So that is how these things get different. Okay. uh, there are various cases around defamation. You may just want to understand what is defamation more about. Then if we understand, defamation is classified into two heads: libel and slander. Now what is libel and what is slander? Libel is a representation made in some permanent form. Example, written words, pictures, caricatures, cinema, films, effigy, and statue, and recorded words. So, for example, you can say it is a libel when there is a article which is being written, when there is a picture which is being displayed, or a film which is being created, and there is some portion or some incident with reference to that, or there is a statue or some recorded dialogue or a movie or likewise. So it is when you see that there is such kind of words which are being used, then it is called as libel, because the way by which the defamation occurs is through these words, through this report, through this article, through this picture, and that's why we say it is libel. So however, in cinema, films, both the photographic part of it and the speech, which is synchronized with it, amounts to tort. So that is what, because it's a audio visual medium. So there is also a speech and there is also a photograph, like a motion picture, which is also there. So, slander is the publication of defamatory statement in a transient form, a statement of temporary nature, such as spoken words or gestures. So here it can be just spoken words. Now the question is, now sometimes there is these spoken words also get recorded today in today's world, right? Now whether can you say this is a libel or it's a slander? So here what is important: slander is a publication of a defamatory statement in transient form, that is statement of a temporary nature, such as spoken words or gestures. So here, generally the punishment for libel is more severe than for slander. Obviously, the reason being, when there is a cinema, when there is a written word, so these kind of things get circulated very easily in today's world. Plus, the impact is to the larger audience. Wherever, when if it is a spoken words in a meeting, for example, or in a yeah, so here the audience is very limited. Now forget about that it was not being recorded or likewise. But here, when it is just spoken words, the impact is only to the audience which is being created. But otherwise, this written words, this the articles get circulated, or it can be widely kind of be published. So here, that's why libel becomes a very different thing. In India, both libel and slander are treated as a crime. So if you see section 499 of the Indian Penal Code recognizes both libel and slander as an offense. However, torts in criminal law are stricter than in law of tort. So here, libel and slander under IPC both are treated as an offense. Okay. So now we saw battery, we saw assault, malicious prosecution, we saw false imprisonment, we also saw what is defamation. Now we are going to see what are the judicial remedies which are available. Because like we saw, whenever there is a right, there comes a remedy. So obviously when it is your rights have been breached, there should be a remedy, and what remedies are available to you at hand is of importance over here. So three types of judicial remedies are available to the plaintiff in an action or for tort. Now there can be damages, there can be injunction, and specific restitution of property. Now we are going to understand what is extrajudicial. So we have discussed about damages, we have discussed about injunction and specific restitution of property. Now, what are the extrajudicial remedies? So in certain cases, it is lawful to redress one's injury by means of self-help without recourse to the court. So these remedies are, so without recourse to the court, you can have these remedies. Now, self-defense. It is lawful for any person to use reasonable forces to protect himself or any other person against any unlawful use of force. Now, obviously, if there is now the reason why these are extrajudicial remedies, because it is lawful to redress one's injury by means of self-help. So what are the key points or key words which are being used? A, it is lawful. Okay, this is lawful to redress one's injury by means of self-help. So here I am helping myself, because I can't go for every time to a court of law and kind of, unless of course I wish to do, but it's not every now and then can go to a court of law and then do a particular thing. And of course, sometimes the time demands that I need to take some steps for it, right? To protect me, to protect from being assaulted, to protect from being causing any battery. So here it is an important, I afterwards I can go. So these are sometimes an after remedies, right? That somebody has been assaulted, somebody has been, there is a battery which has been committed. So these are after remedies, what can be understood. But what can be the remedy before even I can go to a court of law? So here, what is self-defense? So it is lawful for a person to use reasonable forces to protect himself. So if A is causing a bodily injury to the other person, then of course A has right that he defends himself. Now, for example, he knows karate, and he can use that karate and protect himself and beat B, because B was trying to harm him, or B was trying to create a bodily injury to him. So here he can defend himself, he can use that karate against that other person and try to save his life. So here it is self-defense. So this can be from a bodily injury, to avoid any bodily injury, to avoid any sexual assault, to avoid any assault, to avoid any battery which is being created. So here, to avoid this, self-defense can be the way. Now, prevention of trespass. So an occupier of a land or any person with his authority may use reasonable force to prevent trespassers entering or to eject them, but the force should be reasonable for the purpose. Now, for example, what we saw, that if a person is entering into your house, now obviously what we saw, it can be treated as trespass because it is without your consent and without your willingness that this person should enter into your house. Now, what you would say? Oh, please, you would say first with kind of words that, okay, please leave the house. Now, if that person still doesn't hear, what you'll do? Please, you may pull his hand and say, oh, please get out of my house, right? Now, there is of course a touch involved, there is of course a contact involved. So here what is happening is you're preventing a person from trespassing. Now here what is important, you're ejecting that person from your house. But the force should be reasonable. Now if you push that person and throw that person, or put a gunpoint that please get out, then it can be a different story, right? But if it is a normal kind of way, please, if you just take his hand and say, oh, please get out, or if you just, it's a small kind of push which you are saying, oh, please, now the person is not listening and you're saying, oh, please get out of us. So the force here should be reasonable, right? The word that's why is being used, reasonable. If you push deliberately that person and you throw that person and you beat that person, then that cannot be treated, may not be treated. Of course, it depends upon the situation and what defense you take, but it should be reasonable purpose. So that is what prevention of trespass. Now, re-entry on land. A person wrongfully dispossessed of land may take repossession of the land if he can do so in a peaceful and reasonable manner. So what is important over here is, now for example, we always see that there is encroachment on lands, or there is illegally people come and stay on the land, they build their houses or build their homes or temporary homes on the premises or the lands which are being owned. Now here what is being said, you can it's your land, so and you are being wrongfully dispossessed of that land. So, possession of a particular land or a property is very important feature in the terms of ownership, right? So, whenever why we say that, oh, you can't enter or it's a trespassing, because you own that land, you own that property, and you don't want unauthorized access by other people to that particular property. So here, when there is a wrongfully dispossession of a land, like somebody has encroached the land and you want to do it. So if you just whatever construction they have made and you kind of uh, temporary structures are being built, and then if you destroy that, but in a peaceful manner, of course there are a lot of conditions attached to it. So how you do it is very important. It should be peaceful and in a reasonable manner. So these two conditions are important: peaceful and reasonable manner. So that things goes, and if you are being retaking the possession of the land, then of course that is okay. Recaption of goods. So it is neither a crime nor a tort for a person entitled to possession of a chattel to take it either peacefully or by the use of a reasonable force from one who has wrongly taken it or wrongfully detained it. So here it was about the land, now it is about the goods in possession. So abatement of nuisance. Now, this abatement of nuisance is also important. The occupier of land may lawfully abate, that is, terminate by his own act, any nuisance injuriously affecting it. Thus, he may cut overhanging branches as spreading roots from his neighbor's tree, but upon giving legal notice, by choosing the least mischievous method and avoiding unnecessary damage. So nuisance is also an important thing. Now nuisance can be because of the trees which is being caused. So there can be various ways by which this nuisance is created. So here what is important is injuriously affecting. Now sometimes like what is being mentioned over here, that the roots of the plant are, or the plant is in the others premises, it's not in your premises, it's in others premises, but of course the roots are coming to your foundation of the building, or the roots are affecting, or the are affecting in a manner by which it's creating nuisance for you, or your parking is getting damaged or likewise. So here what is important is you may kind of terminate by his own act. So you kind of take steps to prevent this from happening. But what is important is you give notice. So either you can tell that person, please do the needful. So it is kind of giving a notice, of course. So here you are giving notice to the person that, okay, I'm going to cut here the roots. So this is the day I fix that the roots are coming in my premises and I'm going to cut over here, by choosing the least mischievous method. Now, if you kind of cut the tree as a whole, of course, I don't think it is the right way to do, right? It's the least mischievous method, by which, why least mischievous, in the sense there is a little damage which is caused by it, the minimal damage which is being caused. Now, of course, there might be issue to the trees, but if you cut the tree as a whole, then of course, I don't think it's the way by which you can do. Avoiding unnecessary damage. So, if by which you break their wall or destroy their wall in that process, then of course there's a problem, right? But if you do it in a less mischievous manner without making unnecessary damage, now some damage can happen while doing this, but it's a minimal damage, and it's avoiding unnecessary damage. So if because of which their entire wall falls off, then of course I don't think it is justifiable. So that's why this you can be doing it, but it has to follow the conditions which are given over here. Now we are going to see distress damage. An occupier may lawfully seize any cattle or any chattel which are unlawfully on his land, doing damage there, and detain them until compensation is paid for the damage. The right is known as that of distress damage feasant, to distrain things which are doing damage. Now you can imagine a scenario where this cattle goes in the field of some persons, and they start eating all the vegetables which are being grown over there. Now obviously the person or the owner of that farm may get pissed off that, oh, this, I've got a fantastic farm produce, and this cattle is eating all the farm produce which I am producing. So obviously here what the person can do is which are unlawfully. Now it is a law, the person owns that farm. Now the person has got a farm producer, like he has produced some vegetables over there, he has grown some vegetables over there, and which are unlawfully. Now the cattle is unlawfully on his land, so that land belongs to that person, and the cattle is of some other person which have been wrongly entered into the farms of this person, and of course they are doing damage over here. So damage is also being caused to the farm produce. So here this person can detain them until the compensation is paid for the damage. So here the other person can detain on the cattle and say, please pay the compensation because your cattle has destroyed my farm produce, destroyed the vegetables which I was growing. So here, first pay that compensation, then only I'll release your cattle. So here, the right is known as that of distress damage feasant, to distrain things which are doing damage. So basically, I'll give you the cattle, but first, whatever damage the cattle has made to the crop, plus first pay that, then only I will give you the cattle. So this can be the scenario where this is, and the word, proper legal words are distress damage feasant. Okay, so this is what you understand by distress damage feasant. So by this we end the chapter of torts over here. So we have gone through all the chapters. Now I like to take you through. So we completed, I'll just check what all we have completed so far. So we completed Constitution, we completed General Laws, Indian Contract, Laws of Tort, Elements of Company Legislation, Elements of Company Law. We also completed Legal Reasoning, Logical Reasoning. We'll see some aspects of now verbal reasoning, and we have also gone through some chapters of uh, verbal reasoning and non-verbal reasoning. Let's see if we have completed it, and where, till what extent we have completed. Okay. So we completed assertion and reason, right? So we have completed this. Blood relations also we have discussed. Decision making we have discussed. Yes, this also we have discussed. Yes, the bill thing we have discussed, that okay, this is a tax bill, this is a recreation bill, this is a school bill. We have discussed this and we have taken this. We have also seen inserting missing characters. We have also discussed this, that what is missing characters. And I do remember we have discussed about this example. Then logical sequence test is also we have discussed. Logical Venn diagram also we have discussed. Number ranking, time sequence. Yes, we have discussed. Syllogism also we have discussed. Okay, let's take these examples. Some mangoes, I'm on page 265. So you can open of the PDF, so you can open page 265. So some mangoes are yellow, some tixo are mangoes. Now what is the conclusion? Some mango, which they have mentioned, some mangoes are green, tixo is a yellow. What do you think? What can be the answer? Yes? Yes, none follows, neither one nor two follows. So I guess this is easy to answer. Some ants are parrots, all the parrots are apples. What do you think about this? Conclusions, all the apples are parrots, some ants are apples. What do you think? Yes, only two follows. So I guess this is simple to understand. We'll also see non analytical reasoning. Now, this is also very important. Uh, have you done this before? Oh, see this. So what we can do is, I guess I'm seeing some questions on principles, legal principles. There are some questions. So let's see legal principles. Yes, because some of you had mentioned me that you are finding difficulty in the legal principle. And since we have done most of the, like we have done all the chapters on tort, we have done all the chapters on company law. So I guess this can be now easy for you to understand. We'll also go through some of the maxims. Most of them we have already done, but let's go through the maxims as well. So I'm on page 134 of your module and 136 of the PDF, because this is what we will take today and complete. So we have got time. So what my plan is, we can complete legal terminology to some extent, some brief we can study on the maxims, and of course on the legal principles. So ab initio we discussed. So where have we used ab initio from the beginning? Anybody remembering? Contracts? Yes, yes, contracts, void ab initio. Do you remember this phrase? Yes, perfect. So void ab initio, that is it's void from the beginning itself. So that's what void ab initio and void is used, or ab initio is generally used in the context of contracts. Then absolute sententia exposure non-indigent. Plain words require no explanation. Actio mixta, that is mixed action. Now, actionable per se. So, the very act is punishable and no proof of damage is required. So, here, actionable per se. What is actionable per se? That the very action is itself punishable. It requires no proof of damage. Now, where you can say about torts, or likewise, can you correlate something over here, that it is, you don't have to show that there was some damage which is caused. Yes. Okay. What else? Yes, injuria sine damnum. So basically, if it is trespassing, it is punishable. Is there any proof of damage that, oh, the damage to a property has been caused? No, there may not be any damage to the property which has been caused, but the action itself is punishable. You can't enter somebody's premises, right? So then we will go to the some other maxim. Actus reus is wrongful act. Ad hoc is for the particular end or a case at hand. So that was, we say, it is an ad hoc basis. This has happened in the sense it is haphazardly or for particular end or case at that hand. Ad idem. Where have you seen these words? Ad idem. Yes, consensus ad idem. Yes, perfect. At the same point. So it's used in the same context. The context consensus ad idem, that is at the same point. A meeting of minds, if you remember, that's what we discussed. Then ad valorem is according to value. Amicus curiae is a friend of court member of the bar who is appointed to assist the court. So sometimes in a case or a difficult matter where there is something which is very important or has to be understood in a different sense, requiring a special knowledge of that particular area, then this is said that, oh, this person is being appointed as an amicus curiae, that is a friend of the court member of bar who is appointed to assist the court. So in files which are being filed, so if you refer to the when there was a law which was being created on the sexual harassment of women at workplace, so there were people who are being appointed as amicus curiae to help the court that, okay, how can this be treated, so that they are treated as a friend of the court who helps the court to assist in the particular case, that how this can be best dealt with. Then audi alteram partem, here the other side. So this is the principle, one of the principle of natural justice. What is the yes, natural law of justice, that for example, if I say that, okay, this person, for example, I say, oh, this person did not do the homework, for example. Now the person has to be given a chance, right? That whether he has done the homework, whether there was a problem and that's why he could not do the homework, or likewise. So the other side also has to be heard. You can't just draw conclusions. So imagine if the court does not give the other party any right to present the case. Would it be the principle of natural justice being followed? No. The natural justice may not be followed because the other side might also have a story to present. The other side might also want to tell something, that why this person is being come. So both the parties are being heard in the court, right? Both the parties are being heard, and uh, then the judgment of the court is being given. So here audi alteram partem means here the other side. It is one of the principle of natural justice. Benami is nameless. So you must have heard benami in the land transactions, or in case of transactions where there's property or shares involved, that is benami, that is nameless. So the name appearing may not be the truthful owner. It might be some other person who is really owning that land or property, but it is being shown in the name of some other persons. So you must be hearing this benami transactions in the case of politicians, that they may hold so much land, say for example, and it is not the real person. It may not be that person who is named or shown on the records, but it might be somebody else who has actually invested the money, and the name of some other person is being displayed. So it may be treated as a nameless or benami transaction. Bona fide, we saw good faith, genuine. What is opposite to bona fide in a way? Yes, yes, malafide, perfect. So, bona fide, it is in good faith, genuine. Caveat, what is caveat? A caution registered with the public court to indicate to the official that they are not to act in a manner mentioned in the caveat without first giving notice to the caveator. Now, understand this is a very important thing. Caveat. So, sometimes there might be an apprehension that a person may file a suit against, institute a suit against a person or a company for that matter. So, for example, if it is an intellectual property or a patent with some there might be some dispute which is going on, and the other party may feel that, so therefore two companies, there is a dispute which is going on, A and B company, and B company may believe that A might institute a suit against B company. So here they may file a caveat in the court saying that please don't pass any orders without giving us the chance to first represent what we have to say. So a caveat is a caution registered with the uh, public court to indicate to the officials that they are not to act in the manner mentioned in the caveat without first giving notice to the caveator. So you give us notice and let us respond to that, and then only you please pass the order. So that's what is called as caveat. Caveat emptor, let the buyer be aware, let the doer be aware, and caveat venditor, let the seller be aware. So these are the famous maxims in the, again in the kind of consumer related transactions, that let the buyer be aware, let that you should be aware of this. Certiorari we have seen, this is a writ. What are the other writs which we saw? Habeas corpus, right? You remember? I hope you remember. Yes. Uh, Consensus ad idem we saw, then damnum sine injuria we saw. De facto, that is in fact, de jure is by right opposed to de facto in law. De horse, it's outside, again foreign to. Now this de horse is, we studied the doctrine of impossibility, section 56 of the Indian Contract Act. We also discussed about COVID scenario and all. If, oh, hope you remember, force majeure and all. Yes, doctrine of frustration. So here, if it is dehorse of the contract, so dehorse of the contract means it's outside the contract. It's not there in the contract. So that's how this typically the word is being used. Dehorse, that is outside. So it is dehorse the contract means it is dehorse. It's not there in the contract. It's outside the contract. Then deceit, against anything intent to mislead another. Del creder agent also we saw in the types of agent. Then yes, this is again important. Delegate, potestas, non-potest, delegary. Now what is this? A delegated power cannot be delegated further. Now this is an important maxim, also used in the context of the board powers or the powers assigned to a particular director, that whether a delegation can, so if there is a delegation to a director that okay, you do this particular thing, can he further delegate it, is the question. So here a delegate cannot delegate. So delegate, potestas, non-potest, delegary. A delegated power cannot be delegated further. So that's what it is being meant. Estoppel we have seen. Again, this is very important. Ejusdem generis. This is a rule which is being used in the statute of interpretation, that how we are going to interpret a particular section, a particular words which are being used in the statute. Now, what is this ejusdem generis? Now, this is a very, the ambit of this is very large, but I'll just try to help you in very nutshell. Where there are general words following particular and specific words, the general words must be confined to the things of the same kind as those of specified. Now I'll help you with an example to understand this principle or maxim. For example, if I'm saying or if I'm defining that what are pets? The pets are the animals which are brought home and they are being nurtured, and they are being brought out with the family of individuals, and they are like, for example, dogs, cats, likewise, or etc. Now the question is, I've used dogs, cats. Now, can a lion fit into this category? What do you think? Can a lion fit into this category? No, the reason being, A, what are the general words? Now I am using pet as a general word. Now try to understand here. Now I'm using pets as a general word. So pet can be anything. Now you have to understand whether this particular thing can be in the ejusdem generis or not. So if you have to interpret whether the lion is a pet or not, you will have to go by the general words following particular words and specific words. The general words must be confined to the things of the same kind of those specified. So I've specified, right, that cats, dogs, I've specified. So those are domestic animals, what we can say. But now here, lion is a wild animal. So whether ejusdem generis can be applied and whether can you say that lion is a pet or not? So the answer is obviously no, because the ejusdem generis, that is the general words, must be confined to the things of the same kind as those specified. So you have to apply that principle. So that's what is called as ejusdem generis. Estoppel is obviously we have seen in partnership, we have seen here in contract as well. Estop, that is stop from denying. So you, if I say that this person is my partner, or I showed my consent and the person said that I was this person is my partner and I did not act, and I the other person acted on and I know that the other person acted on that behalf, that oh, this is my partner and that's why he entered into a contract with that person. So later I will be stopped from denying that, oh, this person is not my partner. So you're stopped from denying later on that what you have earlier said, you are now stopped. No, you cannot say that because you have already said something. Now you cannot, you will be stopped from denying now that this person is not your partner. So ex parte means proceedings in the absence of the other party. So ex parte means if there is no other party which is being present, then it can be said whether, oh, whether ex parte proceedings can happen and whether there is an order against it. Then we can say factum, human foresight. Then what we can say, which is very force majeure, is what we have seen. Generalia specialia bis non derogant. General things do not derogate from special. So special are things is something. Habeas corpus we have seen. Ignorance legis we have seen. Ignorance of law is no excuse is a famous legal maxim. You have to, the question is you have to remember all maxims. Ideally you it's better to remember because these are not just see, there is something which can be from an exam perspective and something which is really a knowledgeable thing which you should be knowing. So most of the things fall in the second aspect, that it's not just for your exam, right, it's for your understanding. So it's good that you understand all these maxims and then try to understand what does that mean. Ipso facto is by the very nature. Then impromptu is in readiness. I guess it's simple to understand. In specie is in kind. Then let me see what are the intravires is what we have seen. Intravires. What is the opposite of intravires which we saw? Yes, ultravires. That's right. Ultravires. Where we have seen ultravires? Yes, where we have seen. Where have we seen company law? Yes, thank you. Ultravires what? The memorandum of association. In personam is a proceeding in which relief is sought against a specific person. Now, just in rem, right against the world at large. So this is an important thing. Just in rem, that is, it is a right against the world at large. And in personam, a proceeding in which relief is sought against a specific person. So some can be against a very specific person. And this is what? Just in personam and just in rem. So this is what you have to remember. Just in personam, it's a right against a person, a specific person. And just in rem is right against the world at large. So here it can be against one person only, and it can be against the whole world at large. Jus scriptum is a written law. Lis pendens is a pending suit. So the suit is pending. Locus standi, right of a party to an action to appear and be heard on the question before any tribunal. So here, whether what is a locus standi, we say generally means right of a party to an action to appear and be heard on the question before any tribunal. Mandamus, we have seen malafide is in bad faith. We have seen mens rea is guilty mind. Mesne profits. Where have we seen mesne profits? The rents and profits which a trespasser has received made during the occupation of premises. So basically, if there is a trespasser, like if a person has encroached your land and he is earning some rent out of that land, say for example, if he has allowed some shop to be established on that land and he is earning the rent of that shop from the person, now this is a profit which he has earned during his occupation of premises. So this is called as mesne profits. Mutatis mutandis means with necessary changes in point of detail. You may always see this in the share capital or the memorandum of association that the changes in the points of detail shall apply mutatis mutandis, means it will apply in the same manner necessary changes in the point of detail. Then onus probandi is the burden of proof. So in the cases, criminal cases, or in the cases where if you sometimes allege something, then that the burden of proof, what we say burden of proof means it is your, if it is said that the burden of proof lies on this person, means what, that you have to prove that this particular thing has happened. The other person, it is not up to the other person to prove that this has actually happened. So what we say, this is called as a burden of proof. So you have to establish the fact. If it is a burden of proof on me, say for example, then it is my duty to prove that this thing has actually happened. So I have to establish, I have to provide evidence to the court saying, no, this is what has happened. So the burden of proof will lie on me in that particular instance, mean that I have to prove to the court that this is what has happened, which I am alleging. So depending upon the situation, the burden of proof may change. Then paripassu is on the equal footing or proportionately. This is again used in the context of share capital, that the shares shall lie paripassu, and likewise per se by itself action, per incurium, though want of through want of care or through inadvertence. So this is very important. Sometimes the judgments are being said per incurium, that is the lower courts may not have taken proper want of care and then they have delivered the judgment, or it is due to inadvertence. So it may be said that this judgment is given in per incurium, means not with the proper want or care, or it is being given inadvertent. Okay, so that is meant by per incurium. Prima facie, again at first sight or the face of it. So what we see, oh, prima facie, this is the case, in the sense prima facie it looks like the person is the owner of the land just because of seeing the titles and things like that. Prima facie is at the first sight, just by saying something you may believe that this person is the owner of land. So prima facie is again used in very different context. Pro bono publico, for the public good. So pro bono is generally considered as something done for the society without any charges, without any fees which is being taken. So if you see lawyers say, oh, I take pro bono cases. What are this pro bono? That is, I don't charge anything. I just do it for the sake of society. I do it for the sake of public good. So pro bono means, publico means for the public good. Pro forma is a matter of form. So pro forma invoice, you may hear about these words. So what is pro forma invoice? As a matter of form. So it's like a format or which is being given. Pro rata is of course in proportion. So for example, if the shares are given pro rata in case of a rights issue, in like if I've got 4 shares, and in case of a rights issue I say 4:1, then per 4 shares I'll be given 1 share. So pro rata, in proportion I would be given the shares. Then we'll see quo warranto. We have seen quid pro quo. Okay, now just concentrate on this term. Yes, in case of, right, you're right, oversubscription or under oversubscription, I'll be given pro rata shares in proportion to what I have got the shares. And again, likewise, so this thing pro rata is a very common word which is being, or maxim, or which is being used. Where I was, yeah, quid pro quo, something for something. Now, what is this something for something? So, quid pro quo is generally, like I told you, it is used. Yeah, please. This has always been a confusion. What is consideration and what is quid pro quo? Generally, quid pro quo is used in a negative manner. Consideration is essential element of a contract. Okay, please understand. Quid pro quo is something for something, and it is not used in the right sense. Meaning, for example, I'll help you in the form of a, if it is in the form of a sexual harassment. For example, like if you come with me for a date, I will give you promotion. Now there is something, you have to come for a date and then a promotion is being granted. Can you say that this is a consideration given for a promotion? Can the word consideration be used in a rightful manner? No, the answer is no, and which is right. What you're saying is right. It cannot be. It is not a consideration, because if you see, consideration is an essential element of a contract. But quid pro quo, that's why if you see, it is used in a negative manner, that something for something. Now, this is something is what here in this particular context, you are coming for a date is something, and what is given in something for that is a promotion. So that's why generally the word quid pro quo or a bribe, typically if it's a bribe which is being given, it's a quid pro quo. So that's what, yes, it's used in a negative connotation. Quid pro quo, which is not something which is right here. What here it is, it's not something which is rightful to do, legal to do. Yes. So that's what the word quid pro quo is. Something is in exchange. It is in exchange for something that you get something. Okay. Yes. So that's why you don't get mixed this with the consideration. Something for something. Quid pro quo is a generally used in a negative connotation. Okay, you can't say that, oh, A is selling goods to B, it's quid pro quo. No. Did you get this, the difference? Okay. uh yes, ratio descendendi, what is this? A principle or reason underlying a decision. This is that whenever you're going to do a legal research, you would say, oh, the ratio descendendi of this case is this. So what is a principle which is being derived out of a particular judgment? So this is what it means, that this is a principle derived from this particular judgment, and that's why it is called the ratio of this cases, the ratio decidendi of this cases, that this principle is being derived out of, like for example, if it's Salomon versus Salomon, what is the ratio of that case, say? Then likewise, so in a particular judgment, what is the principle or reason underlying a particular decision given by the court? Uh, yes, res judicata we have seen. Then the, let me see, rule nisi is a rule which becomes become imperative and final unless cause to be shown against it. We'll see, we have left 3 minutes, so I'll just see what we have to finish first. Uh, Simpliciter we have seen, simply without any addition. Sine qua non, it is an indispensable condition. I guess this is important. Then stare decisis is precedent, literally let the decision stand. Ubere fide we have seen. What are the contracts? Ubere fide, you remember? Yes, anybody? Yes, insurance, right. You're absolutely right. Insurance. Ultra wires we have seen. Usufructuary, one who has the use and reaps the profit of the property, but not the ownership. So this is again, usufructuary is important, one who has the use and reaps the profits of the property, but the ownership is lies with somebody else. Then we'll see vis major, act of God, we have seen when we discussed about force majeure. Vice versa, I guess, again, you understand what is vice versa. And voluntary non-fit injuria, damage suffered by consent giving no cause of action. So this is also we have seen. Now we have one more lecture left. So just a quick round which I want to understand from you, that what would be the chapter, or what are the special portion which you want me to cover, even if I've covered earlier. Just let me know. So I give you a minute or so, and you can help me that what can be the topics which you want to take. Like what should I take? Okay, let me see. Okay, I can't take everything. You have the lectures recorded and you can visit those. It's available on the ICSI student YouTube channel. But if there's something special which you want me to touch upon a particular topic, I can take that. Okay, I let me see what all comes, and then as per that we can check. Uh, okay, you're saying the entire topics, right? You have to tell me something specific about it, because the entire topics, like I told you, you can watch the YouTube channel again, and then you can take that. Okay, so I'm not seeing a specific topic, guys. Okay. Okay, we can do the revision of all topics if that works. Okay, we can do that because that's what I'm seeing. Uh, if possible, we can do a quick recap of all the things, or uh, I'll see if I'm getting any answers to the questions, and we'll also go through the other topics of legal reasoning which I have left, so we can cover that, and we can try doing or solving some examples. Yes, we can do the revision of logical reasoning. Done. We can do that. Okay, sure. So I guess that's what the gist answer which I have got, that we'll do the revision of legal logical reasoning, and the last lecture we would be now doing the revision of logical reasoning. Okay. Okay, no problem. Thank you so much. Thank you. Thanks a lot. Thank you. That I hope you're understanding. You're good. That's good. Yeah, I'm also going to miss you all. Thank you so much. But we have the last lecture, don't worry. Okay. Bye bye. Take care. Yeah, thank you. Yeah, you too. Stay safe.